think some of our folks are at the prayer breakfast. They pray for them to get here on time. So the business of the committee today is to pass a budget so we can pay our people and have money to spend on the business of the committee, to organize, to set the subcommittees and the rules. Senator Feinstein and I think, have reached an agreement on both of those issues, and to take up nominations. And they're large in number, but when you look at the history, I feel comfortable we can do this. Mr. Barr will be up today. I think we need a new Attorney General. I appreciate what Mr. Wicker's done, but I think the time has come for new leadership at the department. When it comes to judges, of the 44, 19 have previously been voted upon, 13 by party line vote. I think we have 7 that we've reached consensus on and regarding a voice vote, and all the other nominees have already had hearings in the last Congress. I'd like to dispose of this and get on to other things for the committee. There was a request made by, I think, Senator Blumenthal and Feinstein to do a hearing about the deaths of the 2 young children in custody, DHS custody. That's going to be set, I think, for March 5th. I talked to Senator Blumenthal about some red flag legislation I'm working on with him. So to my friends on the other side, there seems to be a lot that we actually agree upon, and I would like to make this a productive committee, bipartisan as possible. And with that, I will turn it over to Senator Feinstein.
Thanks very much, Mr. Chairman, and I know this side of the aisle very much appreciates your comments, so thank you. Today, the committee, as you said, is voting on 46 nominees, 44 judicial nominees, as well as William Barr's nomination to be Attorney General of the United States. I'd like to first address Mr. Barr's nomination. As I have said from the outset, the question for the Senate is whether he is the right person for the job at this time. Special Counsel Mueller is in the midst of an investigation into Russian interference in the 2016 election, whether any U.S. persons were engaged in those efforts, and whether there has been attempts to obstruct justice. That investigation includes both criminal and counterterrorism allegations. It has already led to 37 indictments and guilty pleas, including 6 of the president's former advisors. This is also expanded to include investigations and cases in the Southern District of New York, the Eastern District of Virginia, and the District of Columbia's U.S. Attorney's Office. Special Counsel Mueller must be allowed to finish, and other Trump-related investigations and cases must also proceed without interference, with the underlying facts and evidence shared with the Congress and with the American people. This report must be made public. At Mr. Barr's hearing, I asked several questions about the investigation and the report that Mueller is expected to produce, and so did a lot of other senators. I also sent 2 letters following the hearing asking for Mr. Barr's commitment to provide the report to Congress and not interfere with the investigations. Unfortunately, Mr. Barr would not commit to providing Special Counsel Mueller's findings and the final report to the Congress, nor did he answer my letters. This is particularly concerning, as nothing in existing law or regulations prevents the Attorney General from sharing the report. In fact, as part of our oversight responsibilities, Congress routinely requests and receives confidential information to closed investigations. And in the most recent example, Congress asked for and received investigative information, including transcripts of FBI interviews of witnesses involved in the examination of Secretary Clinton's email. The president routinely tweeted, and Republicans demanded all information be turned over, and it was. The president has said that release on Mueller's report will be totally up to the Attorney General. This clearly means that this nominee, to me at least, is reluctant to state a position, and that's troubling at the very least. Mr. Barr wrote an extensive, single-spaced, 19-page memorandum 5 months before being named to this post. He provided great detail and legal arguments for his view of the president's absolute authority. Under his theory, the president is above the law in most respects. For example, Mr. Barr argued that conflict of interest laws cannot apply to the president because they, quote, would impermissibly disempower the president from overseeing matters, including those in which he has a personal stake. Mr. Barr concluded that the Constitution, quote, places no limit on the president's authority to act on matters which concern him or his own conduct, end quote. That's page 11. And he argued that certain presidential actions, including firing FBI Director James Comey or telling the FBI to go easy on Michael Flynn, can never be obstruction of justice because the statute does not explicitly name the president. That's the memo at page 10. This is a stunning legal argument. Also, it was given to the White House prior to his appointment. Taken to its natural conclusion, none of our laws would apply to the president unless the president is explicitly named. In fact, when combined with the view that the president can interfere with investigations into his own conduct or that impact his personal interests, the only conclusion is that the president is above the law. That's stunning. To argue that the president has no check on his authority flies in the face of our constitutional principles of checks and balances. But the arguments made in Barr's memo go even farther, to assert that presidents have no limits on their power to insert themselves in law enforcement matters, even those involving their personal interests. And that can't be acceptable to any of us. I believe the memo is disqualifying. I'm also concerned about Mr. Barr's evasiveness when asked about Roe v. Wade. To many women in this country is all important. Specifically, when asked whether he still believes that Roe should be overturned, Mr. Barr would not provide an answer and instead spoke to past practices of the department. And when Mr. Barr was asked, would you defend Roe if it were challenged, he replied, and I quote, I mean, usually the way this would come up would be a state regulation of some sort and whether it's permissible under Roe v. Wade. And I would hope that the Solicitor General would make whatever arguments are necessary to address that, end quote. Bottom line, he did not commit to defending Roe or to fighting state efforts to restrict a woman's constitutional right to choose. In addition, Mr. Barr was not willing to distance himself from the president's harsh immigration policies, including the president's threats to nullify the long-accepted constitutional guarantee of citizenship to anyone born on U.S. soil. When asked about this specific proposal, Mr. Barr refused to agree that the 14th Amendment guarantees citizenship to those born in the United States. I personally find this very troublesome, especially given the plain language of the Constitution. I also asked Mr. Barr about legal prohibitions on torture and his comment that, and I quote, under the laws of war, absent a treaty, there is nothing wrong with coercive interrogation, applying pain, discomfort, and other things to make people talk, so long as it doesn't cross the line and involve the gratuitous barbarity involved in torture, end quote. This statement was made despite the existence of a Geneva Conventions and the United Nations Convention Against Torture. And when pressed, Mr. Barr would not affirm the well-established position that waterboarding is torture. Thanks to Senator McCain, I was his co-sponsor, the law now confines all interrogation to the points laid out in the Army Field Manual. Now for comments on our blue slip tradition. Unfortunately, Mr. Chairman, and I wished I had a chance to talk to you about this earlier, we are now seeing a departure from this tradition. Today, this committee is voting on 4 circuit court nominees who lack support from home state senators. This is really unfortunate, and it's brand new. And we're proceeding with these 4 nominations despite the lack of 6 blue slips. I would urge this committee to reconsider. We've seen firsthand what happens when blue slips are honored. For instance, President Obama worked with Georgia's 2 Republican senators, Saxby Chambliss and Johnny Isakson, to reach an agreement on 2 nominees to the 11th Circuit, including Julie Carnes, who was recommended by the 2 senators. And during the Trump administration, when the White House has worked with Democrats to identify district court nominees, consensus nominees have been identified and confirmed quickly, as was done in Pennsylvania with Senator Casey. As Senator Strom Thurmond argued to then chairman of this committee, Ted Kennedy, in 1979, and this is a quote, "This is my 25th year in the Senate. Ever since I've been here, I was told by senators who've been here a long time before I had the custom that was, before I heard the custom, was that if any senator failed to return a blue slip, a nominee would not be considered by the Judiciary Committee." Senator Thurmond went on to say, and I quote, "I do not favor this committee running roughshod over any one senator from any one state." I hope this does not begin to happen today. Thank you, Mr. Chairman.
Thank you, Senator Feinstein. If we could, I'd like to move to adopting the budget. Senator Feinstein and I have agreed on the committee's authorizing resolution, legislative council drafted marked ROM 19111 and circulated to the committee members. We have a majority of the committee present. I'd like to adopt this resolution by voice vote if we could. All in favor say aye.
Aye.
All opposed, nay. The ayes have it, and the committee's authorizing resolutions adopted will be reported. In terms of committee organization, Ranking Member Feinstein and I have agreed on the committee's rules and subcommittee assignments and circulated both to the committee members. We have the proper quorum present, and I'd like to adopt the committee rules and subcommittee assignments in block by voice vote. All in favor say aye.
Aye.
All opposed, no. The ayes have it. Thank you very much. Now to nominations. We have before us 44 judges, the head of the Marshal Services, and Mr. Barr, as I previously said. 19 of the judges on the calendar for the day have been previously voted on by the committee. 13 along party lines. I doubt there'll be a change there. 7, we've reached consensus. I think the district court judges, hopefully we can do by voice vote. All 44 have had hearings, and I would like to proceed to the nominations and get this done by today, and so we can move forward in the committee with new business and sort of have a fresh start here. So with that, I want to give my colleagues on the Democratic side as much time as possible. The 2-hour rule, I've been told, will not be waived, so that means we have to do our business at, we cease to exist at 2 o'clock. So I would propose at 12:45 we start voting and get through these nominations, and that will give us all a chance to talk. On our side, we'll limit our side to 30 minutes. Sorry about that. But I'll give you about 2 hours to talk about Mr. Barr and anything else you want to talk about.
Mr. Chairman, just note one thing on the I believe I'm going to want a roll call on most of the
Yes, sir.
nominees, especially because the blue slip
Yes, sir.
policy, which has
Yes, sir.
always been followed, today it was not followed.
Yeah, no, okay. So I would like to make a motion that at 12:45, we begin voting on the committee's nominations. All those in favor? The clerk will call the roll.
Mr. Grassley.
Aye. Say aye.
Mr. Cornish.
Aye by proxy.
Aye by proxy.
Mr. Lee.
Aye by proxy.
Mr. Cruz.
Aye by proxy.
Mr. Sass.
Aye.
Mr. Hawley. Aye. Mr. Tillis.
Aye by proxy.
Ms. Ernst. Mr. Crapo. Mr. Kennedy. Mrs. Blackburn. Aye. Mrs. Feinstein.
No.
Mr. Leahy. Mr. Leahy.
No, I said.
Mr. Durbin. Mr. Whitehouse. Ms. Klobuchar.
Proceed to whoever you want to talk.
Yeah.
No by proxy, sorry.
Mr. Coons.
No by proxy.
Mr. Blumenthal. No. Ms. Hirono. No. Mr. Booker.
No.
Ms. Harris.
No by proxy.
Mr. Chairman.
Aye.
Mr. Chairman, the votes are 12 yeas, 10 nays.
With that, we will discuss the nominees, and at 12:45, we'll begin to vote. So a very brief statement, I'll turn it over to my Democratic colleagues and let you have your say about Mr. Barr and everything else. In terms of the blue slip process, when it comes to district court judges, nobody is going forward unless we get consent from senators from their state at the district court level. Excuse me, district court judges. As to the circuit court judges, 17 of the last 19 chairmen, I've been told, have had a policy where you consult, but the blue slip was not a veto. Senator Leahy, during his time as chairman when President Bush was president, enforced the blue slip policy where you couldn't go forward unless you had both blue slips returned. Senator Eastland, back during the Brown Board of Education days, was a strict adherent to that policy, which some say resulted in a lot of judges being denied. The one thing I can promise my Democratic colleagues, and all this happened before I got here, is that I will get in a room with you when it comes time for circuit court nominations and see if we can find a compromise with the White House. I'm going to do this the golden rule. One day you'll be in charge. It's just a matter of time, and one of you may be president on this committee. The odds are pretty good. Like half the people in the committee are running for president. So all talented. If you get to be president, and I'm still around, I'll try to work with you the best I know how, but sometimes we just can't agree. So that's the blue slip policy. I think I'm consistent with the traditions of the committee, and I promise you a good faith effort to find common ground where we can. With that, I will turn it over to Senator Feinstein if you'd like to speak any more or recognize anyone on the Democratic side.
Can I just make a quick point about the blue slip to appeal to the grace of the chair? So the judge, Mr. Mady, who's up for a circuit court position, the White House had represented to people on this committee that they had consulted with us. I gave a very different representation of the facts, but even more specifically to your willingness to sit down with me and the White House. In the open hearing, I asked for a meeting with Mr. Mady. I spoke about his willingness to sit down with me because they hadn't even done that yet.
You haven't had a meeting?
No, sir.
Well, you'll get one.
And can we hold on him until we at least get that reset?
He'll be going to the floor, and I'll make sure you get the meeting.
Thank you, sir.
Okay.
Before we go too far into the blue slip thing, where I think we all have a lot to say and where I think there's a lot at stake, I just wanted to note Rule 4 of the committee, which says that debate shall be terminated, which we just agreed to do, if the motion to bring the matter to a vote without further debate passes with 11 votes in the affirmative, one of which must be cast by the minority. Now, I don't know whether it's the majority's view here that because we didn't immediately end debate, because we agreed to a little bit of time and then we'd end debate, but not have full and complete debate in the committee, Rule 4 doesn't apply. But I think a Rule 4 does apply, because I think we just did vote to end debate in the committee. And by my count, although I didn't hear the clerk rattle off who had voted,
Right.
my understanding is, and I'd like to have it confirmed now, that there was no vote cast by the minority, and therefore I think we stand in violation of Rule 4 right now as to this effort to cut off debate.
I'll be glad to reply to that. Apparently, Senator Hatch and Grassley have done this in the past. Rule 4 does not prevent us from setting a specific time for a vote. Chairman Hatch in 2003 interpreted the rule as one designed to permit a vote at the insistence of a member of the committee, even if the chairman doesn't want to vote. But the text of the rule plainly does not apply when the chairman moves to call a vote. Chairman Grassley twice set specific times for markup votes by motion in 2018. The parliamentarian of the Senate confirmed Chairman Hatch's interpretation in 2003 and confirmed the Chairman Grassley's interpretation in 2018. So I'm following their precedent, and hopefully in the future we won't have to do these things. Apparently, the 2-hour rule is not going to be waived today, so that was the dilemma.
Could I mention on the, Mr. Chairman, on the, I'm not sure the Senate parliamentarian ruled that Senator Hatch was correct. I think the Senate parliamentarian said this is a matter for the committee and not for the Senate. There was a concern because, as sometimes happened with Senator Hatch, he had committed one way and then went a different way when the
Well, I'll look into that. That's what my staff is telling me.
And if I could make a point on the blue slip, Mr. Chairman.
Please.
I believe that there is a Rhode Island seat on the First Circuit Court of Appeals, and when that seat becomes vacant, I expect that Rhode Island's views about who should occupy that seat will be considered by the President. And I think each of us have a similar situation. We have circuit courts, which are not state by state, but we believe, and there is a tradition in the Senate, that there is a South Carolina seat on your circuit, that there's a Texas seat on your circuit, that there's a
Until Bush changed
Nebraska
that.
seat on your circuit. What makes that happen? It's not in the Constitution. There's no statute that says so that I'm aware of. In my view, what makes that happen is our convention and agreement and comity with one another that we will honor each other's assertion of our rights as to that seat.
I can't find.
So, the only way we enforce our rights to that seat is to the blue slip. I have no other method. It is that and nothing else. So if this committee wants to trash the blue slip, then in the event of a different president and in the event of a different majority in the Senate, where is your remedy when a liberal lawyer from New York, who's not even from your state, gets appointed by the president to South Carolina, North Carolina, Montana, Nebraska, Utah, wherever? We haven't thought this through because we're so eager to move these judges that we're willing to break down the blue slip. But if you've got no blue slip, you've got nothing that says that there is such a thing as your home state seat on your circuit. Now, there may be a few cases in which circuits were expanded and there was a more formal division, but for many of us, that's not the case. It's only our convention, our comity with one another, and this tradition that allows there to be a Rhode Island seat, for instance, on the First Circuit. So I'm going to be really hard-pressed to say when there's a South Carolina seat that comes up on your circuit, Mr. Chairman, and there's a Democratic president, we have the majority, that we should consider anybody from South Carolina for that seat. Why should we? You've got nothing to say because you've got no blue slip left. We are unilaterally disarming the Senate Judiciary Committee in a way that will have collateral damage well beyond the immediate goal of packing the courts with these nominees in a great rush.
If I could build out upon that and respond.
Mr. Chairman.
Let me respond, please. I said all that in 2013 when we changed the rules to go to a simple majority for circuit court judges. Everything you said is true, and it's going to get worse over time. The day that you dealt yourself out as a minority to have a say about who gets on the court was the day that everything changed. Used to be, you'd have a lot of say about who got on the court because you needed 60 votes. The history of the Senate was to seldom, almost never invoke 60 votes. Most Supreme Court nominees were placed on the court even without a hearing. The politicization of the judiciary, there's no use blaming one group, is real. And after 2013, everything changed. Now, what did we do? We had Gorsuch. We couldn't get 60 votes. We changed the rule for the Supreme Court. I think you're on the PBS interview that I was on, the story. What's going to happen? Judges are going to be more ideological because you don't have to reach across the aisle to get anybody's input. And it's going to have an effect over time on the judiciary that I very much regret. Everything I said in 2013 has come true. As to the blue slip, the idea that the blue slip was a veto is not accurate. 17 of the last 19 chairmen did not allow senators to have a veto of a presidential pick. It was a tradition where you considered the input. It was seldom deviated from. If you couldn't find an agreement where you had 2 Democratic senators and a Republican president, you try to get consensus. So what I would say to Senator Whitehouse about Rhode Island and about any other judge, none of us have input if you're not in the majority unless we create it. As to your district court judge, I fought hard because she had a right to pick. The circuit court has never been the way it's being described. It's never been 2 people or 1 person can stop the whole process. It's never been the case. Senator Leahy invoked the blue slip policy during the Bush years. Now, Senator the gentleman from Mississippi, I think, used it routinely. 2 Southern senators didn't like the pick. That was the end of it. And there's some nefarious things done. So when it comes to the circuit court, when that Rhode Island pick comes, I will make sure that we sit down and you don't throw up at the pick. And you can find somebody that maybe we can all agree on, even though you know it to be a philosophy you would not have chosen yourself. And that's sort of where we find ourselves today.
There's just no enforcement of that. And the South Carolina pick on the 4th Circuit, there's no reason for it to be a South Carolina seat any longer.
You're dead right. Now that you don't need a vote from the other side, the blue slip policy is never what you said it was. It was never a veto. It's always a consultative process. That will go on. But, you know, I've worried about this in 2013. I was in the Gang of 14 when we had wholesale filibustering of Bush judges. We said, unless there's an extraordinary circumstance, we're not going to filibuster judges. That held until 2013. And the rest is history. And I regret it. I don't know what to do about it, but I'm not going to let the blue slip at the circuit court level be a veto. I will let it be a process of input. And when it comes to district court judges, a lot of people on my side want to change that rule. No. Senators got to have some say around here about something. So district court judges, we will, if you can't reach agreement, we just won't fill it.
Mr. Chairman, you quoted what I did, and I know you wouldn't want to leave something on the record inaccurate, so let me expand that. You said I applied it during the Bush years. I applied it during the Obama years. I was a chairman longer during the Obama years than Bush years. Incidentally, during the 2 years that I was chairman with President Bush, I put through something like 60 or more of his nominees through the committee. The 2 years that Republicans were in charge under President Obama, they allowed only 20.
And if I could,
but the point is, I did not move any. where I wanted the senators from the states to have a voice. I remember sitting in some meetings, even at the White House, with the senators and the president. They were not going to return a blue slip. I remember the president concerned with me opposing there. I said the Senate has to have the final say on this. As soon as the Republicans came in, everybody told me how fair I was and all during the Bush and Obama to Republican judges, but you completely ignored that the second you came in, even doing the most unprecedented thing this committee has ever seen. That was to block having a vote on a Supreme Court nominee, somebody who had been praised by a number of Republicans before as being the ideal person to go on the Supreme Court. So let's just keep the facts straight. We did oppose it with both Democrat and Republican presidents because I believe senators know best from their state and they ought to have a say in it. You're saying that the views of the senator from a particular state is irrelevant, and that bothers me.
Mr. Chairman.
I will recognize Senator Lee, but just one, you are fair. I work with you on appropriations. You're very fair. Here's the truth about the committee. There's two people on this committee who voted for a Supreme Court nominee of the other party, you and me, and that's it. You're 6 for 6. You voted against 6 Republicans and for 6 Republicans. I voted for everybody. That doesn't mean we're better than anybody else. That's just the reality of how people vote around here. And after the 2013 rules change, everything I was concerned about is apparently is coming true. To Senator Whitehouse, when the Rhode Island seat comes, I'll do my best. A voice yes, a veto no. Senator Lee.
Thank you, Mr. Chairman. I agree with your characterization, and having studied the history of the blue slip rule, it's important to note this is not an inexorable command. It's not something that is codified in the Constitution, in statute, or even in a rule of this committee. It is not to say that it's not something that members don't rely on and haven't relied on in the past. It is, however, important to note that during the blue slip's history, ever since Senator Eastland, we've seen it change rather significantly. The evolution of the blue slip has been a gradual one, but not just gradual, it's been nearly constant. And as you noted, Mr. Chairman, only a minority of the chairmen who have served during the existence of the blue slip tradition have recognized it as a veto on the right of an individual member bringing an objection. And as far as I can understand, Mr. Chairman, your intent, your desire is to keep it keep intact much of what we now know as the blue slip, with the exception of the change that we saw in the last Congress under the previous chairman, where we're dealing with circuit court nominees after consultation with the home state senators. In any event, Mr. Chairman, I appreciate your remarks, and you raised some excellent points. I'd also like to ask to be recognized as having been present and voted in favor of the motion to schedule time certain for a vote.
Mr. Chairman.
Mr. Chairman, could I likewise be noted? Could I likewise be noted?
Thank you. Senator Tillis, Senator Cornyn, Senator Feinstein.
Me? Okay. If I understand this correctly, it involves 4 circuit nominees. Riedler from Ohio from the 6th, Mady from the 3rd, which is New Jersey, and then both Miller and Murphy from Ohio. And I wonder if we can't just hold these. We had a little private conversation, and you weren't impressed with that. And sit down for this side that happens to be in the minority, and maybe it happens mainly when a side is in the minority. The blue slip emerges to be a very big and important thing. And you have to remember, Mr. Chairman, what happened when an appellate court nominee by the name of Garland was held for a year, that things are raw on this side with respect to reducing the authorities, limited as they are, that a minority has. And the history has always been to favor the blue slip because it's a way of working out problems. Now, if you're on in the minority, maybe you can work something out with the White House. Maybe you can't work something out in the White House. But I think protecting this tradition is really important to the camaraderie and the unity that we've had when it's necessary. And I think if the shoe was on the other foot, the other side would be saying some of these same things, because this is an important minority authority that has developed over a lot of years and been supported by virtually every Judiciary Committee. And now suddenly, not over a district court nominee, but over 4 circuit court nominees, it's going to be removed. This raises its importance to this side of the aisle, and certainly to those 2 senators involved. So, you know, what goes up comes down, and I really hope that the other side can consider this, and I would just ask that these 4 nominees be held and that we have an opportunity to try to see if we can't come together on a way that the blue slip tradition can continue. Because if what happens is what I think is going to happen, you're going to get 4 circuit court judges, and the divide is going to increase on this committee, and all aspects of trying to find, all aspects of trying to find a solution have not been put on the table. We had dinner the other night. I really appreciated it. If I'd thought of it, I would have raised it there. I didn't. That's my fault. But I'd like to ask that.
No, I get what you're saying. I got it in 2013. I get it now. As to these 4, all of them had hearings, so they've been before the committee. You've had a chance to ask questions. I've been told by the White House that there has been a consulting process. Apparently, it hasn't resulted in a result that any of you like, and I appreciate that. And I don't know if I get involved, it will be any better, but I'll promise you a good faith effort. And Senator Booker, you will certainly get to meet with this gentleman, but apparently he did have a hearing. Okay,
Mr. Chairman.
Senator Crapo.
Mr. Chairman, I just wanted to give a perspective and an observation on the issue that's been raised by Senator Whitehouse and Senator Feinstein and others today on the blue slip. I studied this really hard because Senator Feinstein and I had a battle over a Ninth Circuit nominee who we felt was from Idaho and who she felt was from California, or that the seat belonged to California. And I really wished that I'd had a blue slip right in that fight. But I learned in that fight that the blue slip does not apply in circuit court decisions. At least it didn't then. In fact, I wasn't even given a blue slip because President Obama nominated a Californian to the seat. And so the only people who could have gotten a blue slip in that circumstance would have been the senators from California. I mean, the whole issue was just bypassed because the president chose not to honor, at least our opinion, that seat belonged to Idaho. My point is this. The blue slip discussion we are having with regard to circuit courts relates to whether one senator from a specific state where we do by common agreement agree the seat belongs to that state, whether one senator can block the president's nomination of a nominee that senator doesn't like. And what we are saying is that the history of the way this committee has operated, with the exception of 2 chairmen, is that one senator has not been able, even if the nominee is from that senator's state, has not been able to block a circuit court nomination because there are other states interested in that nomination, even if the person for that nominee is from a different state. And that's the debate we are having. The notion that we are having a debate over whether states can lose a seat on a court that they believe they have is an entirely different discussion. It's not the blue slip issue. That discussion is one as to whether this committee will honor what Senator Whitehouse correctly said is the tradition that we have honored of allowing states to have certain seats come from nominees from their state. And that's going to happen only if this committee, Republicans and Democrats, come together and protect an individual state's right to a seat they think they have. I believe there is a statute, Senator Whitehouse. I may be wrong. I'm checking. I think the statute says nothing more than that each state in a circuit is entitled to one.
Yeah.
And it doesn't say who or which one. But there are now more circuit seats than just one for most circuits.
Yeah.
And so we do have to have a tradition in here where we protect that.
Yeah.
But I'll tell you, I did a lot of research on this, and there's a lot of circumstances in which a lot of different presidents have said, you know what, I'm going to nominate somebody on this circuit for this particular seat from a different state than the last one, and it happens quite regularly. We are the ones who need to enforce that principle, and we've got to come together on it.
But why would we after this?
Well, we haven't, but my point is that egg has
President of our
already
party
been
is
broken
pushing
too.
for a judge, why would we after this?
Well, but Senator, my point is that's a different issue, but that's already been done too. I mean, it's been done multiple times, but it wasn't through a blue slip fight. It was the president saying, I'm going to go here rather than there. And this committee backing the president. That's the fight that I think you are really raising, and it's one that's legitimate, where we among ourselves have to agree which seats really do belong to which states. And then we've got to stick with that.
If I may just respond to Senator Crapo, if I remember this correctly, and the staff has just refreshed my memory, this was a nominee that had left California and moved to Idaho. So it wasn't a California seat.
Well, Mr. Chairman, let me just explain. That is correct. The person who was nominated was a resident of California, but he served his entire term as a circuit court judge in Idaho, and that's where his headquarters were. But when I researched this seat, this particular seat had been in California for a number of years. It had been in, I think, Oregon.
But he left the seat.
Yeah. And he'd been in Idaho for 20 years, and so we could argue over which state had it. And you and I did have that argument multiple times. So I understand you've got your point of view on it. But that's kind of the case I'm making here, is that decision was one that President Obama got to call, and he called it your way. And we backed this committee, against my request, backed his decision. That's a different issue than the blue slip. That's the point I'm trying to make.
Thank you.
Well, I hadn't thought about this until now, but all of us have a certain amount of seats we expect to have in the circuit where we live, state-wise. What I'll do is inventory the committee, and I count me in for the idea that nobody's going to, you may not get the person you like from Rhode Island, but at least they'll be from Rhode Island. Maybe a place to start here. It seems like we all have that interest. But be something to talk about. Senator Durbin.
Mr. Chairman, I want to defer to Senator Leahy, but if we're going to discuss the nominees before us today.
Yes, sir.
I'd like to defer to him first and be next on the list on the Democratic side.
Would you like to talk about the nominees now?
Mr. Chairman, just let me make one point. I'd like just to enter my statement for the record. I know you have my proxy vote. I'm going to leave now, but
absolutely,
and record me as a no.
Without objection.
And I do really, I'm grateful for your generosity in terms of just showing the due respect. I saw this last judge from New Jersey. I'm sort of still in a state of astonishment that I wasn't even shown the respect, and Senator Menendez wasn't even shown the respect, not just even a meeting, but a substantive consultation. Yeah. If you're insisting on moving through, I'll take you up on your offer, though.
You'll get the meeting, but we did have a hearing. Okay. Senator Leahy, would you like to speak on the nominations?
I would, and I may be going in and out because we have other matters before the Congress. We are working very, very hard, did all last week.